the distinguished New York lawyer, author, and lecturer, Alan Schnurman. Each week, Lawline will bring to you the most knowledgeable experts in the field of law today. And now we introduce today's guest and our host, Alan Schnurman.
Welcome to Lawline. Today we're going to examine the existing medical malpractice system and discuss the controversial changes that are now being proposed in the state legislature. Joining us today is Fred Queller, a partner in the firm of Queller, Fisher, Block & Wasowski. Fred is currently the president of the New York State Trial Lawyers Association. Hello, Fred.
Hi, Alan.
Fred, first, what is medical malpractice? Can you define it for us?
Oh, sure. It's not that complicated, Alan. Medical malpractice is really medical negligence. What it means is that, let's say, a doctor departs from good and accepted medical practices. He did something which a doctor of the same type of doctor under similar circumstances wouldn't have done, or he did something that he just shouldn't have done that another doctor would have done. It's very simple. He didn't act reasonably.
Fred, I hear in the media that we're in the midst of a medical crisis, a malpractice crisis. Can you comment on that?
Oh, Alan, there is no crisis. There's a problem, and the problem is that there's just too much medical malpractice. Doctors, on occasion, not all doctors, but some doctors, depart from good practices and they injure their patients. The patients are victims. And under our system, someone who is injured, an innocent person, injured through the fault of someone else, is entitled to be compensated reasonably and fairly for those injuries. And that's all that it is. It's the same as if one drives a car, goes through a red light and strikes someone and paralyzes them from the waist down. That person would be entitled to be compensated. When a doctor does the same thing through medical negligence, then the law says to the innocent patient it makes no difference if he was paralyzed because the doctor gave him an improper injection or he was struck by a car. The same rules of law apply, and there should not be a special privilege class. There's no reason why doctors should be singled out and they should be given immunity. They should be required, and their insurance company should be required to compensate the innocent victim, the same as someone who's driving a car causing the same problem.
But Fred, how do you answer those doctors that say, well, we can't practice anymore. We can't practice our field of obstetrics or gynecology because the premiums for the insurance policies, which have just been raised, are so enormous that we have to get out of the field. We can't make that kind of money.
Nonsense again. Alan, I'd like you to know that the type of doctor that you and I would go to here in Manhattan, let's say a general practitioner, do you know how much he pays for a $1 million insurance policy? He pays $5,486. Now, according to the medical magazine called Medical Economics, the average doctor sees approximately 5,000 patients a year. That means that you divide the $5,486 for $1 million of coverage by 5,000, and you know how much that comes out to? $1.09 a visit. And they just were given a 55% increase. 55% increase on $1.09 comes out to only 60 cents. That's all his premium is going to increase is by 60 cents. And when I read in the papers and in the advertisements that this medical industry is putting out that because of this increase they're going to have to increase their office visits to the innocent patient by $10 up to $25, Alan, that is a ripoff. If that doctor who just got a 60 cent increase per patient visit raises his cost to the patient by $10, that means he's allocating 60 cents to the premium and $9.40 to his pocket. That's what he's doing.
Yes, but I heard and I read that the insurance companies are losing money. Oh. That's why they needed this 55% increase. What do you respond to that?
Well, I'm going to give you the facts, and I'm going to give your audience the facts, and if you think they're entitled to it, well, then they should get it. The company...
I'm not the judge, Fred.
Well, I'm going to let your audience be the judge. They're the judge. The company in New York State that is owned by the doctors, by the way, and that insures 80% of the doctors in New York has been in existence for 10 years only, since 1975. They started out from scratch with nothing. Within 4 years of going into business, that's from 75 to 79, they had accumulated $513 million in assets. 2 years later, by 1981, they had $830 million in assets. Last year, it had grown to $1,200 million from zero in 10 years. And now, today, they have approximately $1.5 billion in assets from zero 10 years ago. Alan, do you know that that is more money, more assets, than 99% of the corporations have in the United States of America? And I'm going to tell you something else that your public ought to know. In the last 10 years, that insurance company that represents 80% of the doctors has not paid out to anyone injured or even to their defense costs or to their administrative fees $1 single of premiums. Everything that they've paid out has been from investment income only, and there's been so much left over that it has grown from zero to $1.5 billion. For instance, last year, 83-84, because they go on a year from June to June, in 1983-84, that company, Medical Liability Mutual Insurance Company, collected in premiums $166 million from the doctors. But they made on that billion some odd dollars they have in investment income $116 million in profit. So when you add the 166 in premium and 116 in investment, they totaled last year in income between the two of them, income and premiums, $282 million. Do you know how much they paid out for everything? For claimants, for lawyers, for their defense? $120 million. Last year, Alan, that company made $162 million in profit. And do you know that that company was just granted a 55% increase? Let your audience tell me and tell you how a company that went from zero to $1.5 billion, that last year alone made $162 million profit, that in 10 years has never paid out $1 from premiums they collected to anybody, to a claimant or defense. Everything has been from investment income. Why in the world that company was given a 55% increase and why they're claiming they're doing bad? I wish you and I were in that business, Alan.
Well, I know there's proposed legislation in the medical malpractice field now, Fred. Can you basically tell us what those proposals are?
Very simply, those proposals are intended to take away the rights of your audience, the rights of the public, the rights of the injured patient. That's what they're all about. This increase that was given, which was totally unjustified, the clamor you hear in the media from the doctors, the newspaper articles, the editorial articles, all of that is so that the legislature will pass legislation and will take away from the injured patient the right to sue and to be compensated. They call it reform legislation. Alan, we call it right to maim legislation. The reason I say that is that there are two purposes to a lawsuit in this type of field. One is to reasonably and fairly compensate the individual who's been injured through the fault of a negligent doctor. But perhaps even more importantly, it is a deterrence against careless conduct, because the doctor knows that he may be sued if he is not careful. He becomes careful. He tries to see that he does the best job that he can so that he doesn't cause injury. If you take away the fear of the lawsuit, then you no longer have that deterrent factor. For instance, because of the lawsuit, the manner in which children are delivered today is totally different than it was 10 years ago. Alan, we are not finding as many brain-damaged babies today as we found 10 years ago. Very few of those cases, because 10 years ago, they were not doing fetal monitoring, they were not checking it. They were giving this drug called Pitocin, and they weren't monitoring. That's what induces labor. They were not doing cesareans when they should have been doing them. They weren't careful enough on that. So you had a great number of brain-damaged babies. Because of the lawsuit, that whole manner of delivering children has changed, and we're not finding brain-damaged babies anymore. You take away the threat of the lawsuit, and you're going to have that again. So that's why I say the legislation which would take away the lawsuit would be giving the careless doctor the right to maim, because he would not have the fear.
Fred, what does the legislation say? You say it's going to take away the lawsuit. Does it take away the lawsuit?
Oh, of course. One thing, there's some proposed legislation now that says that when a patient goes into the hospital is required to give them a form to sign, giving up the right to trial by jury and to go into arbitration. And then when they get out, they sign another form saying the same thing. And then the advocates of that position say, well, the patient has 60 days to write a letter to the hospital and say, we changed our mind, we'd rather go into a court of law with an impartial jury and an impartial judge, knowing that that would not happen. When a patient goes into a hospital and they're in there and they're presented with a form, they sign it. You sign anything when you're in a hospital. And when they go out, they're not going to be concerned. The patient is not going to think about the fact that they have to write a letter to the hospital to say, I changed my mind. So 99% of these malpractice cases, which always involve hospitals, will go out of the court system. There won't be an impartial judge. There won't be an impartial jury. It'll go into an arbitration system. And do you know what this system proposes? This system proposes that one of the 3 arbitrators who will decide this case will be a doctor. And it will be a doctor from the same medical discipline that is being sued for malpractice, for instance, an obstetrician. The one who will sit on this malpractice panel, which will be, by the way, secret, it will be closed doors, the public cannot go in to see what is going on, that obstetrician is going to have to say that his fellow physician, the fellow obstetrician, was guilty of malpractice and that therefore he should pay. You know and I know that's not going to happen.
Let's assume if I was a claimant and I went before this panel and I did not like their decision, can I appeal it?
Oh, of course not. For all practical purposes, there is no appellate process. There is no, the rules of evidence that apply in a courtroom are not there. Appellate process is not there. It's not open to anyone, to the media or anyone else, so that it's almost a secret type of thing. All of the rights that you have in a court of law are gone. It is just the most horrendous type of anti-consumer legislation I've ever seen. It is legislation prepared for a special privileged class, the doctor. And Alan, why should the doctor, the profession that is the most affluent profession in our country, I want you to know that the average doctor in the United States of America grosses $200,000 in income. And according to the Medical Association figures, that average doctor pays an average insurance premium of $7,100. That is 3.5% of the gross income, which is a tax-deductible item to carry on a lucrative business. Why take away the rights of the public? There's no need for it.
Fred, I'm a bit confused. I read the newspapers, and the newspapers in some specialties indicate tens of thousands of dollars of medical malpractice premiums a year.
Correct.
Now, what fields are those? Those are the doctors that are screaming.
Right. Those are the doctors that are making $500,000 a year, $750,000 a year. The ones who are screaming the most are the neurosurgeons. But Alan, when was the last time you went for a checkup to a neurosurgeon? Do you know how many neurosurgeons there are in the state of New York? 194 neurosurgeons. There are 50,000 doctors in the United States registered to practice medicine. That means it's less than 1/2%. Now, you tell me what neurosurgeon will perform neurosurgery, that surgery on the brain or the spinal cord, for less than $3,000, $4,000, $5,000 for a 30-minute operation or an hour operation. So when that neurosurgeon is paying $50,000 or $40,000 or $30,000 a year, which sounds like a lot of money to someone who's maybe making $15,000, you have to keep in mind that that man is he's grossing $500,000, $600,000, $700,000, $1 million a year in fees. So for that person to pay a $50,000 tax-deductible premium is absolutely a drop in the bucket. You have to recognize that a person who operates on the spinal cord or on the brain is susceptible of malpractice, and if he causes malpractice, and that doesn't mean just making a mistake, it means he departed from good and accepted medical practices, and a jury said that, that person has created the most devastating injury imaginable, either death or perhaps worse than death, quadriplegia, that is paralysis from the neck down, or brain damage. It is horrendous. And do you know what they propose? They propose that there should be either $100,000 or $200,000 for pain and suffering. And who would determine what that should be? Another fellow doctor as one of the 3 panelists. Now, can you believe a 17-year-old child, let's say, that is paralyzed from the neck down by a neurosurgeon, that has to spend the next 60 years in a bed looking at their friends dancing and having a life and wife or children or family, and that person should receive $100,000 for pain and suffering, and that is what the medical industry thinks is fair and reasonable? Why?
But I read that the doctor's position is that unless this legislation or some form of it is passed, that many of their fellow brethren in these specialties will abandon them.
All right, let me tell you the fallacy to that. In 1978, which is only 6 years ago, there were 40,000 doctors registered in the state of New York. There are 50,000 doctors registered today. That means in that short period of time, we've got 10,000 doctors more than we had 6 or 7 years ago. This is during the period of time that they are crying that they're going out of business. The fact of the matter is that we have too many doctors in the profession today, and they are competing with each other because there's so much money being made. So you don't have to concern yourself about that. You tell me what doctor you or I or your audience has gone to where you don't sit in a waiting room filled with people and you have a 2 o'clock appointment and they get to you at 3 or 3:30. And then they put you in a room and you sit in the room undressed for a half hour till the doctor gets to you and a nurse comes in and says he'll be here soon because he is so jammed up with patients. He's going from cubicle to cubicle to cubicle. And by the way, one of the reasons why doctors are being sued today is because people recognize that this has become a money-making operation. It is not the same type of relationship that we had when we were children, when a doctor made a house call. When was the last time a doctor, when there was a child with 104, 105 temperature, went to the house to see the child? They say, "Mother, it's okay, it's 20 degrees outside, don't worry about it. Wrap your baby up and bring him to my office, he'll be okay." Say, "But doctor, got 105 temperature, how can I take him out?" He says, "That's okay, bring him over, I can't make house visits."
Fred, you're president of the New York State Trial Lawyers Association. If you were proposing legislation in the medical malpractice field, how would you alter it?
Why in the world would I propose legislation? The patients don't commit medical malpractice. The lawyers who represent the injured patients, injured through doctors' negligence, don't produce medical malpractice. The problem is that doctors produce medical malpractice and they don't and never have monitored themselves. There is this conspiracy of silence that even when they know a fellow doctor commits malpractice over and over and over again, they never do anything about them. You check the Department of Health and you'll find out that they don't take licenses away. They don't suspend doctors. You take a look, if there are any complaints, it was because of drugs perhaps that someone was on or alcoholism, but not for malpractice. The only alternative to seeing to it that you have good medical care is to have the lawsuit. So why in the world would one want to change a system that has brought justice for hundreds of years to injured people, injured through the negligence of a doctor, and change it? Why would I propose any legislation? There's no need for it.
Let me ask you this. Well, let's assume a hospital knows that a doctor has deviated from the standard. Let's assume in the OR, in the operating room. And he consistently deviates from accepted standard practice and problems arise. Won't they take him off the staff?
Fine, if they do take him off the staff. If one doctor will tell about him to another doctor and they do take him off, then he just goes to another hospital. I must tell you, Alan, that I've had cases where with children where doctors, just because of total sloppiness, inject children, let's say, with intravenous, instead of intravenous being in the vein. We had one case where they put it in the artery, so they closed down the blood supply, and this little girl lost her arm from the shoulder down. What happened to that doctor? Nothing. We had another case where a gentleman, a husband, a provider, a father of children, went in for some minor surgery. They gave him general anesthesia. Instead of putting the air into so that it went into the lungs, they put it so that it went into the stomach. So while the doctor is suturing the patient, he's floundering about with no oxygen coming in, and he dies on the table. Nothing happened to that doctor either. As a matter of fact, I want you to know that these lawsuits are vigorously defended. Cases which are open and shut, they stall them, hoping that they will beat the family into submission. They hope that the lawyer will finally give up because it takes so long. And it is a fraudulent offense. It is a frivolous defense to a meritorious lawsuit that makes these cases go on so long.
How costly is it for a law firm to prosecute these medical malpractice claims?
Tremendously. You have to recognize that it isn't as if you have an automobile case where a driver goes through a full stop sign and knocks a pedestrian down on the crosswalk. There we know that's an open and shut case. We know it's a case of liability. We take it. We have a situation where a patient comes into the office, a client comes into the office and had a very, very bad result. And many times another doctor or a nurse in the hospital would say, I can't tell you anything, but I would suggest you have a lawyer look into what happened to you. That's what alerts them. So they come to us, and we then have to purchase the hospital records. By the way, that costs $1 a page at the minimum. So you many times have 400 or 500 pages of hospital records. That's $400 or $500. Then we have to get a medical opinion because we can't tell really what it is. We're lawyers, not doctors. The minimum fee that a doctor will charge to look at the records to give us an opinion is at least $1,000. So the minimum fee to investigate a case is at least $1,500.
What basis does your firm utilize when they decide whether to take this case or that case?
Well, many times we don't know, Alan. The process that I'm telling you many times requires as much as a year of work to investigate to see that you have a case or not. And by that time, you can have $4,000 or $5,000 in disbursements of the kind that I've indicated to you. And we can have $10,000, $15,000, $20,000 worth of labor. And I think your audience should know that we don't get paid by the patient. Most of our patients are poor or middle class and can't afford to pay fees. It is on a contingency fee basis, which means that only if the case is successful do we get a percentage, which is generally a third. So we will not take a case that we don't believe in the first place may have substantial merit and may be one that is of significance. Now, after we've worked a year on a case and we've got between disbursements and labor in about $30,000, $40,000, or $50,000, if we then conclude that there isn't a case or a case that can be successfully brought on behalf of a client, we will so notify the client and we will discontinue the case because there's just no purpose of putting good money after bad. We take the loss. For that reason, we are very, very careful not to take a case unless we believe it has merit, and after we investigate it, certainly not to keep going forward unless it does in fact have merit.
Of the clients that approach you, Fred, how many actually result in court cases?
I would say that we turn away a minimum of 9 out of 10 claims of people that come to us because many times they are not cases. Merely because a result doesn't come out the way a patient would like doesn't mean it's a case. And many times we investigate the case and we have to discontinue it, not because we don't believe it's a case, but because records disappear. Do you know, Alan, that x-rays, vital x-rays disappear, hospital pages from records, all of a sudden they disappear, fetal monitoring strips disappear, records are changed, written over, and even though there are meritorious cases, these things occur and we know that we will not be able to prove the case and those have to be discontinued.
Fred, from a claimant's point of view, from a victim's point of view, if I'm injured due to medical negligence, medical malpractice, it seems I have to have a very big injury. Otherwise, it won't pay for at least your firm to take the case. Is that correct?
It isn't even a question of our firm. The fact of the matter is that there's a conspiracy of silence. Even when the doctors, the medical community knows that gross malpractice has been committed, they stonewall it. They will litigate and fight everything. So you have to be prepared to litigate against them. That is expensive. And I would say that unless there is an injury of some significance, even from the patient's point of view, you don't want to get involved in lawsuits and things of that kind. It is only cases that are significant and that are fairly clear-cut on malpractice that should go forward. And that's exactly what's happening today. You don't find cases that don't have merit that are being brought.
What about regarding dental malpractice? You go to a dentist and he does extensive work on your mouth and you find out he deviated from a standard. Will that also be included in this new legislation?
Well, dental malpractice is a little bit different, but I would say, see, in most dental cases, although we got $1 million for a young man who had a dental malpractice case because an infection set in and went to his brain and he went blind. So that was a rarity, but usually on dental malpractice what happens is for money, and usually for relatively a small amount of money, $5,000, $3,000, $7,000, it can be fixed. So what happens is on a dental malpractice case, for that type of money, it can be repaired. So it is not a significant type of a case as well. We're really talking about medical malpractice where people are blind, people are paralyzed, people lose arms, they lose limbs. That's the type of thing that we're talking about. And that type of case, to say that a person who has lost a quality of life should only have the doctor bills paid or the hospital bills paid, is a ripoff of the public. Why? Why should there be special privilege legislation for the doctors? Why shouldn't they be responsible? By the way, Alan, when you and I in our legal practice, if we do something wrong and we injure a client because we didn't do something that should have been done properly, you and I are susceptible to a malpractice case as well. Why should we be sued in a court of law by a jury who listens to the evidence and does what's right and gives full damages to our clients? Why should we have that liability, and the doctors who really can commit terrible injuries because of the profession that they're in and what they're dealing with, why should they be immune? I'd like your audience to know that what the press is talking about is taking away their rights to go before a jury of people like themselves who decide what is the right thing to do. That's what it's all about.
Fred, thank you very much. It's been a very quick half hour.
Thank you, Alan. Thank you for having me.
Okay. We've been listening to Fred Queller, the president of the New York State Trial Lawyers Association. This is Alan Schnorman, and thank you for watching Lawline.
You have been listening to Lawline with your host, New York lawyer Alan Schnorman. Mr. Schnorman will be back with you again next week at this same time.